So before commencing our event, on behalf of our Moot committee, I would like to extend my heartfelt thanks to our Dean Sir, Dr. Yugal Kishore Sir, our Faculty Coordinator, Dr. Sunil Sir, for granting us the permission to organize the intra-workshop on the facets of mooting. Mooting is a crucial part of a lawyer career. It not only develops the skill of teamwork and coordination, but also flourishes our research analytical skills of mooting and helps in building up great oratory skills that reinforce confidence in our ability as an advocate. Now, I would like to introduce our keynote speaker, Hiraja Shah, who is a dual qualified attorney. She works as a venture capital attorney in California. She holds a BA LLB honors degree, JD equivalent from Jindal Global Law School, India. She received her LLM from University of California, Berkeley, with a certificate of specialization in business law. She is also the founder of Legal Solars, in an online platform dedicated to help and guide students through their mentorship program, legal research and writing program, and Ask Anything series on Instagram. Now, I would like to request Sunil sir, the faculty of ICFI Law School and faculty coordinator of our Moot committee, to take over the event ahead. Over to you, sir.
Okay, one good morning, our guest, Miss Hiraja Shah, ma'am, and all my dear people. We are really privileged and thankful for accepting our invitation to grace this occasion and these enlightened these the minds of these budding lawyers. Definitely, ma'am, your words may ignite those sparks which can just change the course of their lives. They can have definitely be benefited by your experiences and help them in building good careers ahead. So I would also request our dean sir, if sir is there, to say a few words for our guest and to our pupils. Yugal sir, are you there?
Yes, I'm here. I'm very much ready also to welcome my esteemed learned guest, Madam Hiraja Shah.
Sir, your video is off.
Okay, my video is not working. Okay, now video start. My voice is audible or not, sir? First of all, you tell me.
Yes, sir. Yes, sir. You are very audible.
Okay. So I on this occasion of a workshop on mooting, I, as a dean of the ICFI High School and as a guardian of all my students here, wholeheartedly welcome the very learned keynote speaker of the day, Madam Hiraja Shah from Legal Solar, an organization which has been working for quite a long time. In fact, we are very happy that our Sunil sir has been for the last many years working for development of the professional and organizational and international personal relationship skills among the students. Last time also he has organized many workshops in the field, and this year, a few days back, we have organized a very good workshop on crime scene investigation under the guidance of Professor Sunil Kumar Sahab and Mr. Yashdeep Srivastava. Today again, we are organizing this, and I'm very much happy that a very learned personality from California is here to enlighten you, to inform you and further to develop the professional skills of lawyering skills, advocacy skill, drafting skill, communication skill, listening skill, negotiation skill, and articulation skills. All these skills are very important. So until unless you go for very a number of workshops on mooting uh, or trial advocacy, you will not be capable of having these particular skills. So, madam will be speaking on the topic of mooting, where you will be capable of learning all these skills. So, I'm very much thankful to madam that though she's so busy, and it is late night in the evening at USA, but you have spared your valuable time to enlighten, to provide these professional skills to my students. I'm very much thankful to you, madam. And with this, I thank you. I thank you again, and hand over the mic to Yashdeep.
So,
Thank you so much for having me here. I'm so sorry about this. Were you saying something?
No. Thank you, madam.
It's my absolute honor and privilege to actually be here. So thank you so much for inviting me. And I do hope that everyone likes this session and can gain a lot of knowledge out of it. I'll be sharing a document right now so that it's easier for people to follow. And please feel free to take notes and just follow the entire document. If you have any questions, put it in the chat box and I'll actually answer it while we're going through it, so that we don't actually have to go back and forth during our conversation. We can just get done with the issue when we're dealing with it. So if without further ado, I'd like to start, if that's okay.
yes, ma'am, please go ahead, ma'am.
All right. Let me just share the document. Okay. Can everyone see the screen?
Yes, madam.
Okay, great. All right. So I'll be talking about what actually mooting means and how you're supposed to do it. Now you'll see on the screen that I'm doing a lot of hand gestures while talking. First thing first, when you're talking in a moot court in front of judges, make sure your hands are down in the podium if you are the person who does a lot of hand gestures. I'm a person who does a lot of hand gestures while talking. Like, I cannot talk without actually moving my hands around. And that's how I express myself. So even if you see how I'm talking right now, I'm emphasizing certain words while talking. So just very basic tips when you're actually arguing in court. Have your hands near the podium. Don't let the judges see that you're actually doing a hand gesturing, because that's considered rude for them. Second, emphasize on the word that you want to actually talk about in the argument. So for example, if the argument is about how your client is innocent, then emphasize that, Your Honor, my client is innocent because, and have a pause and then start. Do not start running into the argument saying my client is innocent because so and so reason, and I've written in my argument brief. They will not understand a single thing, just like you did not understand the last 10 seconds of my sentence, right? So let's start on what you will be judged in the moot court. So first we have is the knowledge and command of the issues, including the application of relevant law to the facts. So whenever you have a moot court problem, consider it your Bible, your Gita, whatever you may love the most in your life. That is your entire universe when you're preparing for the moot court. You have to absolutely know what the issues are and what the facts are, backwards and forwards. You should be able to cite with sentence is where on the fact sheet that has been provided by the moot court organizer. Second, persuasiveness. Even if your argument has absolutely no strength, and this has happened to me while participating in moot courts, I knew my argument was weak. but I said it with such conviction and persuasiveness that the judge actually thought, oh, she's right. That is actually what and how it should be. So be persuasive as much as you can. Your ability to answer questions and respond to points made. So we will actually come back to this because there are certain ways in which you actually answer questions and you respond to points made. Your structure and clarity. This is again both written submission and your oral submission. If you do not have a clear and precise structure on how your argument is done. So, for example, let's say that I say that, Your Honor, my client is innocent because of so and so reason. And then you move on to the second issue that is there, whether this case was actually should be presented in this court or not. And then all of a sudden you come back to, but any which ways, my client is innocent. That is not a clarity because you are not structuring your argument at all. What you're doing is just making it a lot more confusing for the panel actually judging you. And of course, like I talked about, courtroom manner, one being no hand gestures, which I do a lot. If you'll see during the entire talk, my hand gestures are really near my desk, so you're not able to see that, but I'm constantly moving my hands below my desk. So courtroom manner matters a lot. And there are certain ways, again, like I said, that you'll be answering, you'll be standing, your posture, everything falls under courtroom manner. So does anyone have any question so far? If not, I can move forward. I would just like to ask Ashish or Sunil sir if you could just note down any question that comes your way and let me know if
Sure,
when
ma'am.
the question comes. All right. So what does actually your mooting involve? Written submission, research, and oral presentation. Of course, the three main aspects. For written submission, um, have a very precise table of contents that actually has every single detail. I am not going to delve into how to make a written submission because of the lack of time and because of only 1 hour that we have today. Um, but just know that there is a particular format for written submissions, and this format will be given by most moot court competitions. So always make sure that you're following that format. Second is your research. Do not think that you can just do research for every day for like 2-3 hours, especially if you have like 4 months of time before your moot court submissions. You need to be researching at least 7 hours a day, even if you have 4 hours, 4 months, sorry, 4 months of time before your written submission to the competition. Reason being that the more you research, the more you'll actually come across several different points, several new issues. You will actually come up with your own sub issues, which actually makes a very good written submission and gives a lot more clarity to the judge as well when you're presenting it orally. So, moving on to the key requirements, like I have already mentioned, identify your relevant issues. Read from every book that you come across, every case, research paper, whatever you may come across. One good thing about research is that always, whenever you're researching, look at the footnotes in every single book that you research. Look at the footnotes in those research papers. Look at every single case that has been um, referred by the actual lawyers in that particular case, and go through those entire judgments. Within that judgment, you will find cases that have been actually referred by the court. So look at those judgments. So this way, your research actually keeps on evolving quite a lot. Um, Simply moving on to team preparation. This is very simple. Divide the team, assign tasks, who will be finding case laws, who will be doing the major written portion, dividing the issues, that you work on first issue and draft, I will work on second issue and draft, and the third person in the team is sort of your researcher who basically gives you all the research points in a written format and has all the research properly uploaded in a folder so that you can actually print it out when you're going for your oral rounds. Make sure you have your arguments straightforward, point by point, practice it with the team. And it doesn't, all three have to research, of course, but if you know in your team that two people have better oratory skills over the third one, of course, divide it accordingly, or just go to your professor and ask them to take like a mock trial and see who has better oratory skills. What would be the format of a moot? I'm sure you know what the format is, that the applicant starts, then it's the respondents, then there's a rebuttal from applicant side, a rebuttal from respondent side, and sub-rebuttals if the court allows. So I hope everyone's clear so far. Any questions so far?
Yes, ma'am. There is a question.
Okay.
Ma'am, the main question which arises in the participants that what amount of knowledge do they have before addressing any kind of a mood problem? Is there any specific requirement that the students must possess the knowledge of particular subjects before commencing any mood problem?
Not at all. I mean, I've done international mood courts when I had actually not studied that subject at all. So it's all about research and it's all about just understanding what is going to be included. You have professors in your university. So, of course, every moot court has a professor who is going to be the head. And you can actually refer to the professors in your university saying, for example, let's say it's a constitutional law moot court competition and you haven't studied constitutional law yet. So you go to the professor who normally teaches constitutional law. You tell them, this is our moot court problem. Could you please tell us what we should refer to and what the basic issues are over here? If it's an international law moot court, you go to the professor who actually teaches public international law in a university. So there is no hard and fast rule that you should actually have knowledge, because you will probably never have knowledge for all the laws out there. I don't. I still don't know half of the laws out there. So no, that is absolutely not required.
Thank you, ma'am.
Any other question? I'm guessing that's
No,
a
ma'am.
no.
You can proceed, ma'am.
All right. So um, addressing the court. I think this is the majority portion of your moot court, is that when you're going for your oral rounds, how do you address the moot court? How do you address the judges that are there? So let's start with how you are actually going to start your introduction. For example, let's say you're the plaintiff side. You say, may it please the court, my name is so and so. I am the counsel for applicant. I will be talking about issue number 1 and 2, whereas my co-counsel will be arguing about issue number 3. This is, of course, you're going to have more than one issue at all times. So make sure that you mention who is arguing what issue so that they know not to ask you a question on that particular issue. Then you say, once you're done with that, if let's say, for example, it's a constitutional law moot court and you have one female judge and one male judge, of course you will ask, may it please the court, the council would like to address the panel collectively as your ladyship or your lordship, whichever. You can pick either ones. A lot of times they make an issue saying, oh, but we do have a female judge here. Why don't you want to address it as your ladyship? In that case, if they say, why don't you want to address it as ladyship? Just say, Your Honor, if it may please you, the counsel is happy to address the panel as your ladyship. So just don't give any reason saying, I don't want to, or because there is a female judge, I thought I should say this. Just say, if it pleases the court, the counsel is happy to address the court as so and so. The other way of saying is, my name is so and so, and I'm appearing for this XYZ plaintiff. Let's say, for example, you have two parties are actually on the opposite sides. Then you just say Mr. X and whatever the name is, and Mr. Y accordingly. But if it's actually entities, then you can always just say that I am the counsel for so and so. Any questions so far on how to start addressing the court?
No, ma'am.
Okay. So one basic thing about addressing the court, like I said, you start with, may it please the court. Then, of course, when you're, and if it's an international moot court, it's going to be different. You'll be addressing them as your honor or your justices. So depending on where the moot court is, you have to decide what the address would be for that panel. Let's say you say, it's international moot court. You say, Your Honor, would you like the counsel to give a brief statement of facts? Always ask them if they would like to hear a brief statement of facts. You don't necessarily have to give them a brief statement of facts. They might just say, counsel, you may proceed to arguments. Let's say they do say, counsel, you may proceed to arguments. In that case, just say, certainly, Your Honor. Never say, yes, Your Honor, or okay, Your Honor, yeah, Your Honor. All of that not allowed. The only word that I can use is certainly, Your Honor, or certainly, Your Ladyship, certainly, Your Lordship, whatever you're addressing the court as. Now, let's say, for example, you made a mistake in your argument and you said something that you weren't meant to say, but it just came out wrong. Then just say, pardon me, Your Honor, what I meant to say is so and so, and correct yourself. Do not say, sorry, Your Honor, I actually meant to say that this and this is the argument. You're losing your momentum there, and they're going to cut a lot of points on your mood and your basic etiquette. So always say, pardon me, Your Honor, what I meant to say is this, and clarify it if you think that the judges have found it confusing, or if in your own head you thought that it was really confusing. When you're talking about and you're arguing about your arguments, you have to transition from one argument to the other argument in a very precise manner that the judges can actually follow you. So let's say you're arguing the first point. So you'll start with, first, I would like to argue that so and so, so and so. Coming to my second point, and that's how you'll actually transition into the second point, so that the judges know that you're moving on from your first sub-argument to your second sub-argument. And let's say that you're actually running out of time. Like when you introduced yourself, you said that, Your Honor, I would be taking 10 minutes to argue issue number 1. 10 minutes are being reserved for issue number 2 and 3. That will be argued by my co-counsel. And the remaining 5 minutes will be used as rebuttal. This is how you've divided your time, for example. And let's say you are running out of time and the clerk has given you a sign that you have less than 2 minutes left, and you still haven't gotten to point number 2 and 3. So then you quickly just say, which brings me to my second or third point, and the best way to actually would put it forward would be so and so, and just give a summary of point number 2 and point number 3. Now, let's say you've run out of time. you ask the court, may it please this court, the counsel seeks additional 2 minutes to finish their argument, or the counsel seeks permission to have additional 2 minutes to finish their argument. In this case, the court can either say permission denied, permission accepted. If they accept, great, go ahead, you have 2 more minutes to finish it. If the permission is denied, you just say my co-counsel will now be arguing issue number 2 and issue number 3, and you move ahead. Any questions so far?
Ma'am,
Yes.
yes, ma'am. Ma'am, there is a question that when the time bifurcation is given or made to the judges, and the speaker is not able to clear the facts, so in that situation, if he gets confused, then what should be the approach that he may apply in the moot court competition?
So, okay, so in what exactly are you saying? Like, what do you mean by are not able to give clarity of
Ma-
facts? Because facts are given to the judges,
yes,
facts are
ma'am.
given to the participants.
Ma'am, the speaker, as in the arguments which he wants to clarify.
Okay, so like I said, if he's run out of time or she has run out of time,
Yes,
simply
ma'am.
ask, may it please this court, the counsel seeks additional 2 minutes to complete the argument for issue number 1. The court will either deny it or accept it. Either ways, if they say permission granted, for example, say much obliged, your honor or your ladyship or your lordship or whatever you're calling them. And if they deny, it's fine. Much obliged, your honor, and pass it on to co-counsel. That's how it's going to be.
Okay, ma'am.
Does that clarify?
Yes, ma'am. Yes, ma'am. Thank you so much, ma'am.
All right. So moving on, let's say the judges are now asking you a lot of questions while you're arguing, and someone asked you a question that you don't really understand, and you want to make sure that you've actually understood the question before responding to it. Always make sure that you've understood the question before responding to it, especially if it's a really, really long question. So in that case, you would just say, Your Honor, I want to make certain I understand your question. Would you mind repeating it or rephrasing it? Just say that. So that way, at least you're not giving any wrong answer or saying something that does not make sense and thereby end up losing points. All right. Let's say, for example, they asked you a question and you don't know what to answer to that question. You have no idea what to answer to that question. You can say, Your Honor, I'm unable to answer this question fully at this time. However, I'm happy to answer this question after my co-counsel is done arguing. There's a lot of disturbance in the background.
Requested to all participants to kindly please mute your mics, or better, I think now it is.
Yes, now it's better. So just say that, Your Honor, I'm unable to fully answer your question at this time. However, my co-counsel would be happy to take this answer up. Always, before you say that my co-counsel will be happy to take this up, make sure that you've actually discussed it within yourselves, that if I am not able to answer this question, note it down and try to find the answer. The researcher would be there to help you find the answer. So always make sure that you have that arrangement from beforehand. If you don't have it and you've forgotten to have that arrangement, just say, Your Honor, I'm unable to answer this question at this time. However, I would be more than happy to get back to you after my co-counsel is done arguing. Now, of course, presenting the issues, I've already gone through this. Whatever it may be, you start with Your Honor. The first issue deals with so and so. Introduce what the law is, what you'll be actually referring to, and start with your first sub argument. Phrases that you should never use, in my opinion, Your Honor, not allowed. Or my learned friend, not allowed. If you're referring to the opposite side, just say, my opposing counsel makes a good point, however, fails to reflect upon, or whatever that you're doing in the rebuttal, but never say, my learned friend. Phrases that you should use in your moot court arguments is, in my submission, I will show that, and give like a 3-line summary of what your argument is going to be like. That really actually helps the judges understand the flow of your argument and gives a structure to it. Then when you're concluding, you say, it is my respectful submission that, sorry, it is my respectful submission that so and so are the points, and give that. Or you can also say, it will be argued that, or I will be arguing that, whatever works for you. You need to have command over your own language. So if you're not comfortable saying, it is my respectful submission that, and be very careful when you're saying this. You cannot say, it is my respectful submission that I will be talking about so and so arguments, and I will be also, look at the pace at which I'm talking right now. It is my respectful submission that, emphasize on the words, emphasize on your argument, practice 10,000 times before your actual moot court rounds, time yourself, and you will figure out what are the most important points to touch upon in your particular issue, what are the most important arguments, and create an outline. Now, like I said, if you're talking to the opposing counsel, you say opposing counsel's argument overlooks the fact or overlooks the case from this particular point. If you want to disagree to the judge, just say, I appreciate your point, Your Honor. However, I would like to submit that, or I would be arguing that, so and so. And let's say now you want to always refer to your brief during your arguments. So whenever you're arguing, make sure that the judges know where you're talking from. So say, may I bring the court's attention to paragraph 5, page number 3 of so-and-so, line number 7, however you may like it. Cite the cases at all times. If there's an argument dependent on a particular precedent, say, may it please the court, I wish to open the case of so-and-so reported in this particular volume of the Supreme Court review, or whichever. If it's international law, then ICJ, or if it's a particular high court, then say that, and would like to refer to paragraph number 5 of my submission where this case has been cited. The researcher, if you're the researcher in the group, quickly, the minute this has been pointed out by the person who is talking, open that particular printout that you have, which has that page and the argument highlighted from that particular case. So let me give you an example. Let's say that it's international law, and the person who's arguing in your team says that, may it please this court, I wish to cite a very important article, Article 38 of the International Court of Justice Regulations, which states so and so, right? Automatically, the first thing that you should do from your research pile that you have, open up Article 38, which is highlighted. Of course, always highlight the things that you'll be using in your submissions and have a copy for the judges separately and your own copy. Give one copy to your friend who's arguing and give the other copy to the clerk who will give it to the judges. So this way, the judges actually get a copy of what you're talking about. Any questions so far? I am guessing that's a no.
No, ma'am.
All right. So if it's a very, if it's a case that has achieved a lot of media presence and was highly known to every single person, for example, okay, running out of examples here, but let's just say you are talking about you want to refer to the judgment of Nath Foundation, Article 377, right? So you can ask, is the court familiar with the case of Nath Foundation? Because it's so widely known in India, you can ask that question, and the court would reply saying certainly. Then you go ahead and you present that particular case. Again, when you're presenting that case, the researcher, please make sure that whatever you're presenting from that particular case, you give it to the panel and as well as to your friend who is arguing, just so that they have an exact copy. You can also ask, would you like me to state the facts of the case, Your Honor? If they say, counsel, you may proceed without the facts, great. If they say, counsel, please do state the facts of this particular case, you should know that particular case's facts by heart. There is no other way. You cannot absolutely have any one single fact wrong when you're citing cases. So have a rough outline, and this is what I used to do during my moot court prep, is I would have a piece of paper. Let me show you. Okay, so here's a piece of paper, right? Divided into 4 parts. So I'm just going to divide it into 4 parts. It's been divided into 4 parts, right? First part, name of the case, the year the judgment came out, and the citation. Here, facts of the case in like 2 lines or 3 lines, major issue of the case and major argument, and over here, what was the actual conclusion of the case, what was the final judgment. So have this ready and also note down the page numbers of each and every those things. So divide it into 4 parts and do that. Very simple. Do that for every single case that you have cited in your written submission. Even if it's in the footnotes, the judges can ask you, counsel, you have cited so and so case in your footnotes on page number 7 of your written submission. Could you please elaborate on how this case is relevant to your submission and what is the effect of this case on your argument? You should know that on the top of your head. It should be as easy as saying A, B, C, D, E, F, G, H. It should be that easy to use. So always have that sheet in front of you so that it's easy for you to refer. Think, certainly, Your Honor, in this case, the judgment came out and so. Here, this is the citation, as you can see in the written submissions. Would you like me to state the facts of the case? They'll say yes or no. Move on to your most common issues and the arguments. And the court decided this in this particular case, which is why, Your Honor, this case is very relevant to the submission that I am making, because the arguments used and the judgment that was delivered is very similar to the situation of my client in our case, whatever it may be. Any questions on this particular aspect? Okay, that's a no.
Ma'am, on this
Yeah.
aspect, we do not have a question, but we have a question on another aspect. So can
Okay,
we do
go
it
ahead.
now or we'll do it later?
I think let's do it later because I don't believe we have more than 15-20 minutes left.
Yes, ma'am.
Okay. Um, okay, just in general, like I said, important to be aware of the origins of the case, understand the impact it will have. You can cite legislation fully, know the legislation you're citing. You can cite books and other materials. Your presentation style, speak out clearly, like I am right now. If you speak like, so in this particular case, I would like to argue that I don't think you guys understood what I was just saying. So be very loud, be very clear. If it helps you, do a lot of vocal exercises. Shout at the top of your voice if you're a very soft spoken person. I'm personally not a soft spoken person, so I always had this loud voice that helped me a lot. But even in real life, moving a bit away from our current topic, even when you graduate and you become lawyers, having command over your own language and the way you speak, very, very important. So if you're soft spoken, start practicing that skill because you will need it in the future. Um, if you do not know an answer to a question while you're arguing, you can confer to your co-counsel saying, Your Honor, I would like to confirm with my co-counsel on this particular question and get back to you. Or like I said previously, that my co-counsel would be happy to take this question up, or I am unable to answer this question fully, and I would be happy to get back to you. Present your case. Do not read from your return submission. If you start reading from your return submission, say goodbye to that round. You have officially lost that round. Um, be as flexible as you can. You don't need to have a written summary of what you're going to say. Just know what you're going to say. You should know your arguments by heart, know your facts by heart, know the issue by heart. So that way you actually won't need a piece of paper. I never needed a piece of paper because I always had it in my mind. This is what I'm going to say, and this is how I'm going to say it. And I practice it like 10,000 times. So documentation, like I said, the researcher, please have a full documentation which has one part case laws, one part as legislations, one part as research papers that you're using, one part as um, all the important points in your written submission. And so, okay, so here I have a particular folder that I use for my daily use. And I use it for like a lot of reasons. Like sometimes I forget where I am with my clients. So I always have like a folder that reminds me, even though it's already there on my laptop. I'm a person who refers to hard copy a lot more. So have a similar folder with you, right? And in that folder, divide it by case laws and have those sticky notes on the side that can pinpoint you to the exact case law. So, for example, have a green sticky note on the side that says case laws, and under that, you'll have sticky notes of yellow color that point out the exact case. Finally, when you're ending your arguments, you can say, in summary, the counsel for the appellant makes the following points. If the court has no further question, the counsel would like to recite the prayer section of the written submission. And the reason why you say recite the prayer section is because that's what you're asking the court to give. That's what you're saying, that court firstly give declare that my client is innocent, second give so and so injunction or whatever it may be, and finally when you're dealing with rebuttals, when your opposing counsels are actually arguing, make sure you're writing down their arguments. Even you have their written submissions, right? Read them, see what they are arguing, and write down their arguments in their own written submission, and so that you know what exactly you have to rebut about, because you may have one argument that is way stronger than their argument. So always have rebuttal and focus only on those particular points and your rebuttal. And if you're replying to the rebuttal, it has to be extremely brief. So that was it. And I hope this crash course on how to argue in a moot court and what all is involved in moot court was helpful. So now I'll be open to questions.
Yes, ma'am. Ma'am, the first question, which is coming from the first year, that what should be the approach in selecting a moot court competition?
Sorry, could you repeat that?
Ma'am, the students who come in the first year, so they
Okay.
want to get through or get to know about the moot court competition, and they want to participate, but the major problem they face is that selecting the moot memorial or the proposition. So what should be the
I
approach
mean,
for the first year students?
um, to be honest, I like, at least in Jindal, the moot courts were sort of divided by the professor. So you would actually submit yourself with other two team members um, for that particular moot court, and then the professor would decide. That's how we worked, because we would have a lot of people who are interested in moot courts. So, like I said, there is no hard and fast rule in what moot courts you could go for. As long as you're good with your research, good with how to analyze everything, go ahead and do it. But if you're a first year, I wouldn't go for moot courts, because you're still learning how to basically form your arguments, how to write legally, how to actually articulate yourself. And that cannot be there in first year. You've just come out of high school, senior high school, and you've just given your CLAT or whatever other entrance exam it may be. So I wouldn't recommend that first years actually go for moot courts at all, because you have a lot to learn. Start from your second year. First year, just focus on having those legal skills of research, of arguing, of articulating, of analyzing. But again, if you want to go ahead and do it, you can. But my recommendation would be, as a first year, don't.
Yes, ma'am. Ma'am, the second question is how to improve researching skills for a moot court competition.
So again, researching is quite, it's a journey. It's a marathon, it's not a sprint. So you have to absolutely know, first of all, what is the issue that you will be looking at. So you have your broad issue. Start with the broadest point in that issue. Look at cases that directly deal with that issue. You'll come across cases, you'll come across articles, you will open up your mullah and mullah books. At least that's what we used to refer to. So open those books, go through that extensive amount of theory that is there, read through it. When you're reading, you'll understand what the issue is, what the section is, what actually that particular theory means. And that's your first point of researching, just gathering basic knowledge about that course or about that particular legislation. Then you move on to actually researching the keywords, and only use those keywords. So your issues will have like, let me see if I have like a moot court. I'm not sure if I still have a particular petition from my law school days. But let me search for it so that I could actually give you a full. I think I do have one, but I'm not sure where this came from. Let me just open it up. You'll actually get an idea about this. Give me a second.
Sure, ma'am.
Okay, I think this is from a really, really old moot court competition that I had judged or helped with. Let me share the screen. Okay. So I don't know again what this is for. This is, like I said, really old. It was obviously related to international law, and it was regarding. Okay, so if you don't know what a written submission looks like, this is what a written submission looks like. You have a cover page that has where the court is, so the International Court of Justice in this case, where it is, what is the case regarding. So it's regarding self-determination and establishment of democratic setup. These are the parties to the particular case. This is your table of contents. So you will actually have issue number 1, if you can see here. I think now you can see it. So the first issue was whether BOLR is a part of sovereign territory of Suriname pursuant to the instrument of accession dated 26th October 1947. Now, my first research will be 1, sovereign territory as keyword, 2, accession as keyword, and just basically understanding what that is. When I come to that, then I realize that there's an Article 31 that refers to accessions and how that applies to instruments of accessions. So I move on to understanding what Article 31 is. Let's click on this. Okay, so we have our Article 31. These are all the judgments, and this is just one citation, if you can see, right? What all we're actually citing. So when you're researching, you'll obviously first come across, the first thing that we came across was the Botswana and Namibia judgment. From there, we actually found a research article, which was regarding the dispute between Costa Rica and Nicaragua. So we read about that. From there, we also came across this particular book that had been referred to in it. When you're going through the books, again, look at the footnotes, look at what that particular author is citing and what that particular author's opinion is. So that's how you actually research. You have to look at every single source that you can come across. So does this help?
Thank you, ma'am. Thank you for that screen sharing. Ma'am, the next question is how to cite and how to cite relevant case laws for the moot problem. Like there are numerous number of cases, and while researching, students come across a lot of cases. So what should be the approach in citing the case laws for the competition?
So of course, like I said, the first case that you come across becomes your main case, because that's where you're getting the other cases from, and that's where you're getting your main argument from. Let's say, for example, right? So again, let me do a screen share because that's a lot more easier. Um, okay, so let me just go back to the top. Okay, over here, I will obviously have like an index of authorities. And in that, we have a section for cases, I hope. Okay, we don't. We cited all of the authorities together. So let's just go to one of the pleadings. Okay. All right. So, okay, here we have like a lot of cases together, if you can see, right? That's because each and every these cases cite a similar argument or the same argument. So for example, over here, the words of a treaty are to be interpreted in accordance with their natural and ordinary meaning in the context which they occur. That was the argument that we were making. The question, the issue would have been whether this treaty meant to say this or this particular thing. So our arguments are that the words of treaty are to be interpreted in accordance with their natural and ordinary meaning. And if you can see the citation, one, it's been cited in the advisory opinion in the International Court of Justice. Then this particular judgment, the arbitral award of July 31, 1989, cited it. Then we have the ICJ report 1991, paragraph 53, citing it. And we also have a Polish postal service in Danzig citing that particular case. So you always go by the order in which you found that particular argument. So because we found the argument in this particular citation, right? Here we looked at what else was actually cited in this particular argument. From there, we actually found this. So we also cited that. Then we also cited this. So that's how you'll actually go about it. If it's let's say it's not International Court of Justice and it's actually High Court or Supreme Court that you have to argue in, then of course our Indian citations, like you know how they are, AIR, so and so, 1995, whatever it may be, cite that. Also have the full name of the case. So Mr. X versus State of Gujarat, comma, the citation, page number, so and so, paragraph number, so and so. Give the exact citation, like to the point that if the particular judgment has like lines, then you can also cite line number 10. But Indian courts don't have like lines in their judgments. So yeah, does that clear the doubt on how to cite and research?
Yes, ma'am.
Okay.
Ma'am, it's a request from the Moot Court committee that can you please share the slides, means like share the document with us?
So I actually use that for legal solace,
Okay,
and
ma'am.
so that's why I can't share it. But any questions are most welcome on the Legal Solace Instagram page. Very active, and I do respond. Of course, because of the time
Yes, ma'am.
difference, there's going to be, if you text me at like 2 p.m. your time, I will be sleeping. So you will obviously receive the response only after 8 hours. So
Yes,
always do
ma'am.
keep that in mind. But other than that, yes, happy to answer any questions. Follow Legal Solace. DM us if you have any questions for moot courts. And when you're DMing us, please write your entire question. Uh, do not say, hello, ma'am, I attended your session on moot courts. I had a question. And then I have to respond, oh, what is your question? And then you come up with like parts of questions. Just give your entire question, because that way it's a lot more easier for me to respond and give you a complete full answer.
Yes, ma'am.
Any
So,
other?
no, ma'am, the questions has come to an end. I'd like to ask
Okay.
Sunil sir to please take the meeting forward.
Uh, Ma'am, definitely. Uh, I'm very thankful, ma'am, for you have spared the time for us, and definitely I'm very thankful to you from the core of my heart for enlightening and igniting the minds of these young budding lawyers, and you shared so many experiences and knowledge which are very helpful to my pupils in honing their skills regarding mootings. And ma'am, you have just explained those nuances of mooting in such a coherent manner that I am really, I'm overwhelmed to say that this 1 hour is not enough. Uh, and it seems that this must go on. You are such a good in speaking. Definitely, I can say that you are ingrained with these, those, you are a born lawyer, I can say, because as you said that you are born with this pitch, such a high pitch, and definitely God has paved your way to this profession, and really we are privileged to have you today here. And I request you to kindly find some time. This is my personal request for my pupils, because I'm more than happy if I would have a session again, because this session seems to be quite, just it seems to be that the time passed in a jiffy, rather to say. So you have just told in such a coherent manner how to address the code. Uh, One thing which I always suggest my student, and you too have suggested that is never read the memorials. What I found that in most of the times the students, they just read memorials. Whenever I go for the judging, I ask them, please don't read. Okay, say extempore which you want to say. Don't read it. So this is what I think the student will follow and be benefited while appearing, because moot court is it's just not an exercise to pass this particular degree, a 5 years or 3 years course. But this is, we are preparing these lawyers for the future India, for the future this legal arena. We are just handing them those battles which we have just gained out of our experiences, and we don't want to, because we have faced so many, we might have faced so many failures, and we don't want our those this future generation of lawyers to face all those failures and hurdles in their future profession and their careers. So, man, certainly, and yeah, the way you have told my students that how to prepare the memorials, that was, I think, excellent. And particularly, you have pointed out that what to be included and what to be excluded there in the memorials. So definitely, I think that my pupils have taken the note of that. Even I was taking a note, because I am also the scholar of the law, because you being the part of this profession, because the person who says that now I'm a master in this particular field or a master of this, I think that the day he will say this, he will perish from this field. So the way you have so coherently just given an idea about the format of memorials is excellent. The art of citing, how to cite various case laws, I think it was excellent. So I just I will request my honorable dean sir to say a few words for our ma'am who is addressing from such a miles away, and just igniting our just igniting the mind of these future lawyers. So over to you, sir.
Thank you very much, Mr. Sunil ji. It has been really a very, very great pleasure for me, as well as for you and all my students, that Madam has so coherently, comprehensively, in a so in such a articulated manner, has discussed all the skills which a particular mooter should have. Madam, I'm really grateful to you that within a span of 1 hour, how you have such a meticulously articulated and explained everything with regards to moot court. Madam, it is a great thing that today I found that you have done it, because no one till date have heard so many persons in such a meticulous way. I have never heard, madam. To be very frank and precise. So I really congratulate you, and I'm thankful from the core of my heart that you have certainly done a wonderful job for my students. If whether my students are capable of following it or not, I don't know. But then I'm sure that if they follow in future, they'll certainly succeed. There is no other doubt about it, because the way you have brought it. So, madam, I'm very much thankful to you. And after undergoing through with your 1 hour lecture, I would like to be associated with you. I mean, in this ICFI Law School. In fact, we have got many centers, like Center for Corporate Law and Governance, and Center for Environmental Law and Sustainable Development. And likewise, sir is having his 2 centers. One is the legal aid, and the other is mooting. So, madam, we will be very happy to get associated with you and to take your guidance from time to time. So, with this, I'm again from the core of my heart, I thank you very much, and wish that we should be always be having an opportunity to learn from you. Thank you very much, madam. Thank you. Thank you very much. With folded hand.
Thank you so much, sir. I think this
wisdom
has
and
been
your
like
Londonness.
no, I mean, this is an honor coming from you, especially someone so senior in the field who has a lot of knowledge. Thank you so much for that. I am honestly feeling very privileged and honored to hear those kind words from you. I am more than happy, Sunil sir, to have another session sometime in the future. Of course, my work schedule is a bit heavy, so I always require like at least 2-3 weeks of time so that I can adjust, especially because of the time difference as well. So I'm happy to do another session. I do a lot of sessions on CV review and cover letter review as well. So in case if ever you're required for that, please do let me know. I am happy to do that as well. Just thank you so much for having me, and thank you for all your kind words. I'm
Madam,
glad that you found it useful and really coherent and comprehensive overall. But I'm sure there are other speakers who would have done an equally good job. But thank you so much.
Thank you, madam. In future, whenever you come to India, please make a visit to our Dehradun also, and enlighten our students here. Sometimes when you come to India. Okay, madam.
I would be happy to.
Sure. So have a visit and roam around here, and then have a lecture here for the students. We'll arrange it once we come to know that you are here.
Absolutely.
Okay, because we cannot afford to pay you from USA. So once you are here, then we can easily expand. To be very frank and precise, madam, I'm very clear. To be very frank and precise, we cannot afford to pay you from USA.
I don't expect any payments for guiding law students.
No,
And
madam,
Legal Scholars is exactly what that is. It's an online platform that's free for all law students. I don't charge for the mentorship sessions that I have, or like the training sessions on CV review, or any other sessions that I do through my Instagram. It's all free. It's just what I have learned. I wish someone had done Legal Scholars when I was a law student.
Okay.
That if someone would have told me, do this, don't do that. Luckily for me, my father is also a lawyer, so I had his guidance. But if I didn't have that, I would have been lost. And I know for a fact that a lot of law students are first generation law students and require that guidance. So that's how Legal Scholars actually came up. Seeing my LinkedIn feed filled with students worrying about their career, worrying about internships. So yeah, it's free. There is no payment at all. Yeah.
Okay, thank you, madam. Thank you very much.
So, ma'am, thank you very much. So, this is what I found is after having this bit of conversation with you that you are really a rare combination of good heart and mind. So, ma'am, really, I'm very thankful once again. I'm very thankful to you, and definitely I will have one more session in combination with this Moot committee and the placement cell, so that those students who are just pursuing their careers and then looking ahead to have some good placement may be benefited by your experiences. And you are such a generous man. Definitely, this is what I have realized after this big conversation. So, ma'am, thank you very much for joining. And one, I thank all of one and all, and including I am really, very. I'm privileged to have a dean like Yugal sir, who always encourage their colleagues in all the best ways just to organize such an events for the benefit of our pupils and all this legal fraternity. So with this, by your permission, ma'am, and Dean sir, may I close the session?
Sure, close the session. Okay, thank you, madam.
Thank you, ma'am. Thank you very much.
Thank you, madam.
Now close.
Thank you, ma'am.
So, Yashdeep, you may close the session.